Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before the court will draw near with their attendants, and they shall be heard.
Have a seat, everybody. Good morning. Okay, the first case for argument this morning is case number 156, People versus Jones.
You
may proceed.
Morning, Your Honors. Kathy Reardon on behalf of Kimberly Jones. With regards to point one, the weight of the evidence, we submit that an acquittal would not have been unreasonable in this case, and the jury failed to give the evidence or the lack thereof the weight it should have been accorded. I should preface this by saying we are not contesting the possession count, just counts 1 through 6, the murder, the robbery, and the kidnapping. Okay. Essentially, we submit that the evidence pointed to the co-defendant, David Gardner, and there was insufficient evidence as to Ms. Jones. There are a couple of factors I'd like to draw the court's attention to. Beginning with the video, we submit it was way too grainy to infer that the person walking down the street and the person getting in the car was the same person and that either one was Ms. Jones. The first time that these people are seen together is in Pennsylvania, 8 hours after Mr.
Wasn't it for the jury to determine whether that was too grainy or not? They can look at that and determine, well, those are the blue sneakers, or that's something that very similar.
It's certainly a consideration for the jury, Your Honors, but we're also asking this court as well in its ability to review this case for weight of evidence to take a close look at that video. In fact, at 15:32, basically is when the person walks across the street and gets into the car. And I submit that there is no way to tell who that person is, whether it's a male or a female. And I just asked the court to review that part of the video. Again, the first time they're seen is 8 hours after Mr. Gardner is seen at the ATM by himself, in a car by himself. I know the prosecution says, well, he turned around, looked like he was speaking to somebody. There's no indication that he was speaking to anybody. And it's entirely possible that he was just looking around to make sure nobody was following him.
Is it your position that the strand of hair on the wig, from the wig on the body, that was overemphasized, that was unreliable? I
did actually both. Thank you. I think there's really nothing to establish. Number one, that it was a part of a wig. The only analysis they did is they looked at it through a microscope. There's no indication that it belonged to her wig. There's no indication that they took her wig and matched the two of them together. So I think that's not sufficient to set up in terms of her being at the scene.
We have pretty much a circumstantial case here.
We have I'm sorry, go ahead.
Yeah, an entirely circumstantial case, and the prosecution pieced together all of the pieces in the way they believed and the jury believed, pointed to the defendant and only the defendant as being, one of the perpetrators here. And you want us to look at it in a different manner.
Entirely different manner, because I think there are so many factors in terms of the vehicle fire. It looks like there's a male walking away from it. The phone tracking only had to do with Mr. Gardner. When he went to Jamila White's house, he asked for 1 bus ticket, not 2. And the people relied on Jennifer Hodge, and I'll finish up with that because I know the court's familiar with the video and the record. Jennifer Hodge, I would submit, as a pathological liar, and I think I've explained why in my brief. But the ME said that there were no injuries to the scalp, there was no fracture of the skull, they were unable to establish date, time, and cause of death. And Ms. Hodge spoke to the police 1 week after my client had been arrested, and a simple Google search will show you that a lot of the information that she supplied to the police was all over the media. So I think it's wild speculation that she is any type of credible witness here. Because the evidence didn't exclude beyond a reasonable doubt, every reasonable hypothesis of innocence here, I think that the court should vacate in terms of the weight of the evidence. Just briefly as to point 3 on the sentencing, if this court doesn't vacate, I'd ask it to run counts 1 through 6 concurrently. She's doing 40 to life right now, and I think that the evidence, as I've indicated, did not support this verdict. As I've noted in the brief, she's had an extremely tough life. She's been abused by her father, her mother, anybody she's been associated with. Even her child was abused by the man who impregnated her when she was half of his age. She's had a history of mental health problems, and clearly she was manipulated by this individual when she walked into that pawn shop to pawn the jewelry that he stole. So I would ask the court to consider reducing it if they do not vacate.
Thank you,
you.
counsel.
Good morning. May it please the court, Christina Harper for the people. I would respectfully submit that the verdict here is supported by the way of the evidence. Regarding the evidence that was presented, while a lot of the evidence was circumstantial, there was direct evidence of the admission that was introduced through the testimony of Jennifer Hodge. And
So-
in that,
Do we have to believe her in order to sustain this conviction?
so I think the court has to look at all the evidence taken together. And the jury, I would submit, did look at her demeanor during the trial. And I think that this court should give deference to the jury's determination as to her credibility. As to credibility of Jennifer Hodge, what I would like to emphasize is that while defense calls her a pathological liar, she had absolutely nothing to gain from this testimony. It is very clear that she was already on parole for her conviction. She did not get a plea deal from the people. She testified that she did not review any police reports or media information regarding this case. And if anything, this
Basically, my question was, if we believe her or not, okay? If we don't believe her, the alleged confession is out. Does this case still stand, is my question to you?
Yes, Your Honor, I believe it still does because we still have a lot of circumstantial evidence here, in addition to Jennifer Hodge's testimony. We have the video footage of both co-defendants in the city of Rochester. There is a footage that shows clearly the defendant walking down the street. And while the portion of the video where she's entering the car is somewhat grainy, I would like to point out that she's wearing very distinct wig in that video, and she's wearing the very, very distinct sneakers. And she can be identified, even from that grainy video, as the one who is entering the victim's car. She is also with the co-defendant at the gas station, exiting the car. There's no one else with them, and it's the car of the victim. So the jurors here were given the instruction on recent possession. So they could draw the inference regarding that.
Okay. What about the issue of the sentence?
Regarding the sentencing, she expressed absolutely no remorse. What we have here is a heinous crime committed by both co-defendants, motivated by nothing but greed. We have an innocent person who lost his life in an absolutely horrific way. Even the medical examiner could not really point out as to how exactly the person died, whether he suffered immensely until such time that he died from perhaps dehydration, or whether he died instantly. So given all the circumstances of the crime here and the lack of remorse from the defendant, I would respectfully submit that the sentence was not harsh and severe. Unless the court has any other questions, I will rest on my brief.
Thank you, counsel.
Thank you.
Case number 157, People versus Coffee. Okay, counsel, I think you're all alone.
Yeah, good morning. May it please the court, Allison McMahon on behalf of Appellant Theodore Coffey. As it is just me, I'll be brief, but his conviction must be reversed because the evidence here is insufficient to establish that he recklessly engaged in conduct that created a grave risk of death or that he did so in a way
So tell
exhibiting.
us what's deficient. What's
So-
missing?
The people here, they didn't prove that he was the shooter or that he even possessed a gun, nor did they prove that he acted in a way that showed depraved indifference, which is the culpable mental state. And it's more than just reckless or risky behavior. It's, it's in rare cases where it's like utter depravity, uncommon brutality, and inhuman cruelty. And that just was not present in this case. And as to the grave risk of death, it's clear that the jury didn't find the evidence sufficient as they acquitted him of murder and possessing a weapon. And all
Didn't
the,
find him guilty of intentional murder, right? But
yes,
they found reckless endangerment and wasn't there an individual that he knew was in the car at the time where he went out and fired the gun?
so there was one witness who testified who was present at the scene. She didn't know Mr. Coffey prior to this, but she had rode in the car with them there. However, she testified that after they went into the house, she did not see Mr. Coffey again. She saw a different person after she heard the gunshots, kind of crouching and hiding. And no one else testified that was present. That
But isn't it more important what Mr. Coffey thought or knew at the time? Like if he thought there was somebody out there, that would be reckless endangerment, wouldn't it? If there could have been people in the line of fire, so to speak.
it's if there actually was, not if there could have been.
But the woman who was in the car, I guess he didn't know where she might have been. She stayed in the car, but if she had gotten out of the car, she'd have been in the line of the 9 bullets that were sprayed around the area, right?
It's a possibility, but that isn't what happened. That's not the fact. She was in the car. There was no one else in the line of fire. And to that point, there was not sufficient evidence to prove that he was the shooter in this case. And so I think that's the most important part here is that the evidence wasn't sufficient to show he was the shooter. And even if putting that aside, there was not enough to show depraved indifference. And so the conviction for reckless endangerment can't stand. And for all the same reasons, the verdict's also against the weight of the evidence if this court finds sufficiency not preserved. If there's no other questions, I'll rest on my papers.
So thank you, counsel.
Thank you.
Okay, case number 158 is submitted. Case number 159, People versus Anissa Dows. Both virtual. Okay, can everybody hear me? Okay, we cannot hear you, sir.
I apologize, Your Honor.
There you go. And Ms. Porter, can you hear us?
I can hear you, Judge. Thank you.
Okay, very good. All right, counsel, you may proceed.
Thank you. James Eckert of counsel for the Ontario County Public Defender on behalf of Ms. Dows. The conviction must be reversed because Ms. Dows was entitled to a missing witness charge, which the court erroneously rejected, saying only that she could have subpoenaed the medical witnesses from Clifton Springs emergency. But the missing witness charge only requires that there's an uncalled witness knowledgeable about material issue. And I don't think there's any question that the medical personnel at Clifton Spring Emergency who observed the complainant within a couple of hours of the event, of the receiving of the injury, had pertinent information to provide, both as to what
So,
they observed
counsel?
and
Let me ask you this, okay? My understanding is that those witnesses would have seen, the condition of the body, but there was photographs that were taken and made part of this record of his condition at the time of, at around the same time. Is that right? Or do I have
no,
that?
there were photographs, but having a treating physician observes in a way that photographs don't provide to the jury. And also the treating physician draws conclusions and has other matters. I mean, the prosecution presented only a witness who saw the complainant 18 days after in order to give an opinion, expert opinion, as to how the injuries were caused or what could be excluded or included and so on. So it's clear that the medical people who saw the complainant just a couple hours after had different and better observations to make than a person who saw the complainant 18 days later, when obviously there was a big difference. And I would draw the court's attention to Detective Doby's on page 385 of the transcript, who said the injuries were visibly worsening and changing just as he observed them. So I think there's important information that would have been provided. And also the test for the material witness is just that they not be cumulative. We don't have to know exactly what they would say. Obviously, the witness is missing. We don't know what they would say, but we do know that medical personnel who treated the complainant and made observations would have different and better information, certainly different information than what the doctor who testified obtained by seeing the child 18 days later. And as for the reason being brought to emergency being a mental health reason, that's true, but it doesn't. Emergency personnel seeing injuries are going to make observations. They're going to give treatment, presumably, and the doctor who did testify reviewed the medical reports from the hospital. And obviously that wasn't for mental health purposes. It was for her purposes, which is to deal with the injury. The people at one point in their brief used the word discretion. This is not an abuse of discretion. It's not a discretionary question for the trial court. If Ms. Dows is entitled to the charge, she's entitled to the charge, and it's error not to give it unless the proof is overwhelming, and the proof was not overwhelming. The doctor who testified with regard to whether the injury could be caused by a belt said it depends, it could be. That's not a firm opinion that's helpful to the prosecution case, whereas as to defense, the doctor said, I doubt it. I would have to know a lot more about defense, which to my mind leaves open the alternate explanation, which was offered by the defense. The doctor did firmly exclude bug bites. So the doctor, when she wanted to clearly exclude something, she was able to do it. But as to the two alternate explanations for the injury, she did not express a strong opinion, in my opinion.
First, counsel, first, with respect to the standard abuse of discretion that you mentioned a minute or so ago, we have a Court of Appeals case, People v. Savanon, that doesn't make it clear that this is an abuse of discretion standard?
I didn't think so. My understanding, because I think it's no, because it's if the defense is entitled to and obviously the court's going to review that. I didn't read it that way. But I think if the defendant has established the prerequisites for the missing witness charge, that to just leave it to the discretion of the trial court to say, well, not now. And also, I would say,
now, with respect to the prerequisites, I mean, one of the prerequisites is that the witnesses can be expected to testify favorably to the opposing party. You get an inference because of the. I don't think you need to do much in terms of on your initial burden, but once the people demonstrate that it's cumulative, and in this case, maybe not cumulative because 18 days later, but when you look at the Officer Lloyd photographs, that makes it cumulative because Officer Lloyd took the photographs even before the child went to the hospital. Once they say it's cumulative, now that might be the end of the inference. Now then the burden may be back on the defense to show some other reason why we would expect it to be unfavorable testimony. Is there anything in the medical records that reflected? The medical records suggest that the injury happened some other way?
Well, I don't think that's the test on missing witness. I think the cumulative, if it's cumulative, then that's the counter argument from the prosecution for not giving the charge, because the charge is that the jury is permitted to, but not required to, draw an inference that the testimony would have been unfavorable. As to whether the expectation is the testimony would have been favorable to the prosecution, I think that's clearly the case, because if the I think the test is if the complainants, if the prosecution's case is true, you would expect the medical people who observed the injuries to testify favorably to them. And also, the prosecution never argued that the medical witnesses uncalled wouldn't have been, that was never put forward as a reason to deny the charge, that they weren't, they wouldn't be expected to be unfavorable. One thing that was argued by the people that I want to address is that the defense counsel, in trying to exclude all medical testimony for roughly the same reasons that you're saying, that there's photographs, that there's testimony, we don't need any doctors, did at one point say it was cumulative. But I think in context, the defense counsel argument was that it was cumulative as to the description or pictures of the injury. The jury had plenty with regard to that. But what the witnesses in a medical situation, such as the emergency room, they make additional observations and they come to conclusions. And so there's a lot that goes into having a doctor testify with regard to injuries that they observed. None of the people that were called who saw the injuries at the time, who took the pictures and so on, were medical personnel. So medical personnel.
Counsel, when you go to the hospital, and they observe, but they also ask some questions, wouldn't we have a good idea whether or not that testimony from the medical professionals would have been favorable or unfavorable to the prosecution here? Is it just in a vacuum that we're deciding? Is it just, the physical manifestations of what happened to this child that they would be testifying about?
No, I think the expectation that a witness would have been favorable is simply the category of the witness. For example, it's not, a relative of the defendant who if the people didn't call a relative of, you wouldn't expect them to give favorable testimony. An objective, neutral observer, assuming that people's case is valid, would be expected to provide information helpful to them just by nature of what they are. I don't think, because the witness is missing, so we don't know what they're going to say. That's part of standard in a missing witness charge. You simply know from the category whether they would be expected, that's the test, expected to provide favorable. And there was never any argument below also that they wouldn't have been expected to testify favorably. So, but I think just to address again the defense argument about cumulative, the defense was trying to keep out all medical testimony, saying it was cumulative as to the observations and the injury, but not the nature and cause of the injury. The defense never argued that. So to the extent that the court permitted the doctor to testify, the defense argument really isn't a counter to the missing witness charge, because the doctor testified as to the nature of the injury and its probable cause or possible cause. And so a testimony from emergency would not have been cumulative as to that.
Mr. Eckert, help me out. I'm going to follow up on Justice Nowak's question about being cumulative. The people called a doctor to testify about the injuries, but they didn't choose to call another doctor who wasn't missing. The person was available. They just decided to call a different witness than your client wanted to call.
Well, no, my client, And that's, I think, goes to the trial court's I would argue misunderstanding, which is we're not asking them to call a witness. We're asking for an instruction to the jury that their decision not to call the witness may permits the jury, doesn't require them, but permits them to draw an inference that the witness would not actually have provided testimony favorable to the prosecution. And I think that's an appropriate thing. And as to
Again, I
cumulative,
could be mischaracterizing the record. I'm sorry to cut you. I could be mischaracterizing the record, but from my understanding and my recollection is that they chose this particular doctor to testify because they had experience in pediatric child abuse.
oh, right. I'm not disputing calling the witness. I mean, they're calling this witness is fine, but their decision not to call medical personnel who saw somebody within a couple of hours is just, I think entitles Ms. Dows to a missing witness charge. That they would not have been cumulative to the doctor who saw him only 18 days later when the injuries, trying to determine how an injury was caused 18 days later is not preferable or the same as seeing it within a couple of hours. That's our position.
Thank you.
And
Anything
I would
further?
rely on my brief as to the remaining points.
Okay, thank you, counsel. Ms. Porter?
Morning, Your Honors. Kaylin Border on behalf of the people. The purpose of the missing witness charge is where a party possesses yet withholds superior evidence. And there was nothing in this case to suggest that any testimony from these unnamed witnesses at Clifton Springs Medical could have provided any superior evidence to what was already in the record. As to
Well, you would agree the defense is entitled to an inference. The defense doesn't have to, prove that they would have testified unfavorably. They're entitled to an inference that's within the case law. But the question is by showing that we did call another expert who examined the photographs as well as the child 18 days later. Is that enough to overcome that inference?
I'm sorry, I missed the beginning of your question, Justice Nowak.
You would agree that the defense is entitled to an inference that the testimony would have been unfavorable. The question is then by saying, well, it's cumulative though. Is that enough? Is that enough to overcome that inference? Is that a sufficient reason given by the people?
So I actually, my position would be that they did not meet their initial burden, because their initial burden would have been to say that this evidence was about a material issue, and the victim was only seen for a medical health or mental health evaluation. There was absolutely nothing to say that he received any treatment for his physical injuries. So his mental health evaluation, evidence of his mental health at that time based on these suicidal statements that he had purportedly made, that was not relevant or material to any of the issues at trial. And that's what those witnesses, these unnamed witnesses, purportedly could have testified to. Anything beyond that would have just been their observations of the injuries. But that really gets into whether or not that was cumulative. But in terms of treatment that he received at Clifton Springs was pointed exclusively at mental health evaluations and mental health treatment. And it simply wasn't material to any of these issues. So that would be the defendant's initial burden. Beyond that, I mean, any claim that he received any other sort of treatment is purely speculative. It's based on nothing other than conjecture. He received only mental health treatment. So then even if he had met his initial she had met her initial prima facie burden, the burden would then shift to the people, and cumulative certainly is something that could rebut then the need for that adverse inference.
Okay, what if we don't agree with that? And the counsel brought up the harmless error. Tell us why harmless error doesn't apply here.
Well, because this is an evidentiary, this would be an evidentiary error, then it would have to be a significant probability that it affected the verdict. I don't think that the court's going to get to that point.
Well, let's assume, humor me here since I asked you the question, okay? And let's just assume that the evidence. Counsel's arguing that it's not overwhelming evidence, and you would have to show that it was overwhelming evidence to overcome the harmless error. So explain to us why that's the case.
Well, essentially the injuries themselves weren't necessarily contested the fact that the victim did sustain injuries. So the real question in this trial was whether or not the defendant caused those injuries. The defendant's statements immediately after the defendant's statements, months later to Detective Doby's, really almost cut against any claim that she had necessarily that the victim had. She tried to proffer that the victim had self-inflicted, that maybe he had gotten them from bug bites, that he had gotten them through a fence. So she's clearly showing a consciousness of guilt immediately after the fact that she maintained even when Detective Doby's went to go see her months after the fact. The victim, in contrast, and this is a young child, but the victim was incredibly clear and consistent from the moment that he showed up. He immediately tells the officer that she hurt him, and he's clutching his neck. There's very clear photos of the injuries. His testimony in concern with how he got those injuries was very, very clear. So I really don't think that there's any substantial probability, significant probability that the verdict would have been different and that the defendant would have been acquitted if there was an adverse inference based on not bringing a witness in from Clifton Springs Hospital. So I would say that the evidence is overwhelming, and because this is a non-constitutional error, if the court were to find this to be error, it wouldn't rise to the level that this then becomes a reversible error. But on the charge itself, the cumulative nature of the evidence, I just want to point out that it's not just one doctor versus another doctor. It's all of the evidence that's in the record. And because there's absolutely no indication whatsoever that he received any sort of treatment for physical injuries at Clifton, so it would have just been mental health, then the only thing that those witnesses, these unnamed witnesses, could have testified to is just their observations of those injuries. And to that, there's so much evidence in the record as to what those injuries appeared like on that day when he was actually seen, even to the extent that the photographs that were taken of the victim were taken at Clifton Springs Hospital. So exactly how they would have appeared, even if we're taking Detective Doby's testimony that they worsened over the time that he saw the victim, the extent or what the injuries appeared like at Clifton Springs was documented. And the people brought those photographs in. Dr. Murray testified in regards to each of those photographs of each of those injuries. So we have not only the photographs, not only Dr. Murray's testimony, but we have the victim's testimony as to the nature of his injuries. We have body-worn camera footage, police officers that saw him that night. So it's really all of this evidence that these witnesses that could have come in from Clifton Springs, their observations of the victim would have been entirely cumulative to all of that other evidence regarding the observations of the victim at the exact same time that Clifton would have viewed him. So our position, she didn't clear her initial burden, but then even if she did, this is not material testimony. Even if it was material, it's cumulative. And I also, just to clarify one more point, Your Honors, is the court had mentioned something in the record below that the defense could have called these witnesses. I think how I interpreted that is that even if we get through all of those steps, the witnesses still have to be favorable to the people. So either they're going to corroborate all of the other evidence that was already in the record, and which we would say then would be cumulative evidence, or they're going to contradict it. And if they're going to contradict it, then those witnesses would not be favorable to the people. So then defense could have called those witnesses. I didn't take it as that was the court's impression of the standard for a missing witness charge, but rather if we get to that point, if these witnesses would have been favorable to the defense, they were more than able to call them themselves. Unless the court has any additional questions on that point or any of the points.
Thank you, Counsel. Thank you.
Thank you, Your Honor.
Thank you.
All right, next case is case number 161, People versus McLaren. Okay, Mr. Duffy, can you hear us?
I can, Your Honor.
Okay, why don't you proceed?
Good morning. I'm Casey Duffy on behalf of Mr. McLaren.
Hold on a second. Could you hold on one quick second? We still have counsel from the last case on the feed. There we go. Okay, sorry about that. Now
Sure.
you can start again. I'm so sorry.
No problem. Beginning with point 2 of the brief, the trial court's decision to give a second Allen charge constituted abuse of discretion because the nature and extent of the jury's notes to that point demonstrated that they were hopelessly deadlocked on all counts in the indictment.
Now, counsel, my understanding from the record is that there was no objection, that this may not have been preserved.
Well, at page 814 and 815 of the transcript, defense counsel clearly says that he doesn't think that a second Allen charge is appropriate. I don't think he specifically moved for a mistrial at that point, but I mean, at that point, the court was essentially facing two decisions, or two options. First being give a second Allen charge, and the second would be to order a mistrial. And I think that, you know, his expression of disapproval or the futility of a second Allen charge is sufficient to, you know, rise to the same level as an objection or a motion for mistrial.
And my understanding from the record too, and my recollection is that the court engaged in a balancing of sorts. How much time had they actually spent, the jury actually spent deliberating versus, you know, discussing other non-deliberation type issues, you know, and came to the conclusion that there was still more time would have been appropriate. And I'm assuming you dispute that.
I do. And I think that, you know, the length of the deliberation is just one factor among several. And I think here, the nature and the extent of the jury's communications to the court did indicate that they were hopelessly deadlocked. I mean, they had requested complete readbacks of every key witness's testimony in full and to review or review all of the, you know, significant video evidence that had been presented. And their last question, I believe it was the last question, was whether or not they could infer the defendant's guilt from his decision to testify in his own defense. And I think that really shows that they were essentially flailing or, you know, at a loss of where to go from there. But despite reviewing all the evidence, the scope of the deadlock increased from, you know, disagreement about one count in the indictment to disagreement about all counts in the indictment. Defense counsel, the prosecutor, and the trial court all seem to agree that giving an additional Allen charge would have been useless or hopeless, but they did it anyway. And I think what's especially telling is that after the second Allen charge, there were no additional jury notes or requests for more information. The verdict came back almost, I mean, the timing is unclear, but it sure seems like it was almost immediately. And the verdict came back guilty. So, I mean, taken together, I think all the circumstances indicate that the message delivered by that second Allen charge was you need to reach a unanimous verdict, otherwise you will be required to deliberate indefinitely.
Yeah, but didn't the court have a reason for the second Allen charge that you're not, you know, sharing with us right here? And that there was like a lot of readbacks during the time of the first Allen charge and the second Allen charge, and the court explained that as the reasoning for second Allen charge. Is that true, or?
That was part of the court's reasoning. And I think the exact, I calculated 11 hours of deliberation total, and it is not completely clear what portion of that was spent listening to readback of testimony. But I calculated 11 hours of deliberation.
So with respect to this issue, trying to put ourselves in the shoes of where the court is, you know, you don't want to give Allen charges to the point where you have jurors that are sort of holding firm to their convictions to just give up. You just say, oh, for crying out loud, we're going to be here forever. I'm just going to give in. I'm not going to hold firm to my convictions. And that's not what obviously the charge doesn't say to do that. The charge says to do the opposite. But the other concern that we have on the other side is that people may be more reluctant in this day and age to listen to each other and to truly be open to the idea that somebody's making a point and that, you know, I'm going to listen to the argument, I'm going to listen to the testimony, go back. And so the court seems that they really have to sort of balance those two aspects. Are they really listening to each other as opposed to, am I now pushing jurors on one side to just give in? it's hard for us up here to now look at that based on a cold record, but is that something that we should be giving discretion to the court as to whether they think it's one or the other?
Well, obviously, every case is different. And there are certainly circumstances where a second Allen charge would be appropriate. But given specifically the jury notes here, just indicate that this was a situation where, one or two jurors were pushed over the edge and eventually and essentially caved. I mean, the nature of the unresolved counts got worse over time. And the fact that there were no additional requests for information after the second Allen charge. I mean, the only conclusion I could draw from the record here was that it's exactly the circumstance you described, where a few jurors who could not be swayed heard the second Allen charge and simply caved.
Okay. Anything further, counsel?
Well, I would just like to, assuming I'm running out of time here, the last point of the brief that the sentence was harsh and severe. Mr. McLaren was sentenced to 40 years to life as a 17-year-old at the time this crime was committed. And as even the pre-sentence report demonstrates, that he had been diagnosed with multiple learning disabilities that would have unavoidably impacted his decision-making process at that age. The pre-trial offer was 30 years to life. So we respectfully here think that he should be given the opportunity to apply for parole after 15 years.
Okay, and I guess I did note a very long, even at 17, a very long and violent criminal history.
He did have an extensive criminal record at the time, but again, I even viewing the capabilities of a 17-year-old in making a decision versus him now at 23 is a completely different person.
Okay, well, we'll certainly consider that. Thank you, counsel.
Thank you.
Morning, Your Honors. Brad Osler for the people. I'll jump right into the Allen charge. I don't think under these circumstances we could use this as an abuse of discretion. Based on, and opposing counsel alluded to the fact that I think the judge's calculations on the record that the jury had deliberated about 6 hours on the Friday, 5 hours on the Monday, by the time the second, or the second note that led to the Allen charge came out. Not an unusually long period of time for a roughly week-long murder trial. And I would interpret the jury to the extent that it seemed like they had reached a conclusion on all but one charge, and then maybe that changed a little bit over the course of those 2 days. That seems to me to suggest that they actually were listening to each other, though I would recognize that maybe some juries need to be greased along a little bit to do that. But I think that happened here, and it doesn't seem to me that the Allen charge impeded that or coerced anybody.
And before the court made a decision, it appeared to me that they engaged in that sort of a balancing. How much time have you actually been deliberating, as opposed to how much time were we reading back or rewatching things or whatever? When he decided, well, I'm going to just push it one more time because there'd been so much time not actually deliberate.
Yeah, absolutely. And there were a lot of notes, there were a lot of readbacks and requests for the instructions to be reread. But I don't think amongst all of that, there was any indication that the jury was at risk of being coerced in some manner. And the courts correctly cited the standard that applies. And so I think it was entirely appropriate.
What about the sentencing issue, counsel?
This court reads more PSRs than I do, and some of them are kind of short, some of them are a little bit lacking. This PSR, I think, laid out in a fair amount of depth the defendant's criminal history, which was somewhat extensive. It was rather violent. He had pending charges, or I suppose a companion case, or I shouldn't say companion, but a case ongoing at the same time that was also violent. And we also have the fact that the court system had attempted to give him some assistance. I think he had been to family court at least once. The sentence, certainly I would recognize, is a long one. It's the maximum, but I don't think under the circumstances here, it's eminently inappropriate given the facts and given the history. If there's nothing else, I'm all set. Thank you.
Thank you, counsel. Okay, case number 162, matter of, I can't. Dana, let's call it.
You.
All right, counsel, can you hear me?
I can hear you, Your Honor.
Okay, then why don't you proceed?
Certainly, thank you. Good morning. May it please the court, Julie Filion, for the petitioner respondent, Erie County Department of Social Services. Our position this morning is that the facts in this case support the trial court's findings of derivative neglect against the one child and permanent neglect against the other, as well as the trial court's denial of the requested suspended judgment. And today we're asking this court to affirm those findings and dismiss the appeal. We have submitted a brief. If the court has no specific questions for us, we would submit on the points made in our brief.
I think that works for us. Thank you. Okay, counsel?
Yes, good morning. May it please the court, Natalie Marin from the Legal Aid Bureau on behalf of the children.
Okay, so you both children?
Yes, both children, yes. I would be respectfully requesting today that this court take judicial notice of its own prior proceedings with the sibling children of the children of the appeal today. And those appeals were pending last fall and were affirmed by this court. And with that, I would be resting on my papers today, but I could provide your honors an update on the children if you would like.
That would be nice. Why don't you do that?
Yes, so the children are 3.5 and 2.5 respectively. They reside in separate foster homes, but those foster parents are related. So they do receive a lot of sibling access between each other and also sibling access with siblings that are not subject to these proceedings. They are doing well, walking, full vocabularies, on track, and they are very happy children.
Okay, and they probably look forward to the finality?
They're a little young to fully understand, Your Honor, but yes, I think that permanency would be wonderful for these children.
Okay, I appreciate your comments. Thank you very much.
Thank you, Your Honors.
Okay, case number 164, matter of Tracy Moses. Okay, counsel, can you hear us?
I can now. Thank you, Your Honor. Allison Bates on behalf of the child, Jason. May it please the court this morning. I don't have much to add to my brief. I know that I'm the only attorney appearing today for arguments. However, I did want to update my Michael B. statement to the court. In my brief, I did indicate to Your Honors that my client at the time of the submission of the brief was residing at the Center for Youth. I can update the court further that my client is now residing with a maternal aunt, Miss Perry. That is under a temporary order issued by Judge Mazo in family court. There is a proceeding pending between Miss Perry and her sister, who is the respondent, Miss McFarland herein. And that matter is scheduled for trial on March 17th. My client is very happy living with maternal Aunt Perry. He visits with his mother as agreed. His position is that he would like to stay with maternal Aunt Perry, and that is where he would like all of his overnight times to be and his primary residence. If the court has any questions for me about that situation, that family court proceeding, how my client is doing, or anything regarding my brief, I'd be happy to answer.
Well, is she still visiting her mother on a regular basis? What's going on with that?
Is my client still visiting his mother on a regular basis?
His mother, yes.
Yes, in fact, when I spoke with him yesterday, he was with his mother. He visits as agreed. Miss McFarland and Miss Perry have a great relationship. They are sisters. They're essentially raising the child together. The child is primarily with Miss Perry, but does see his mom regularly several times a week unsupervised. He just does not sleep at her house.
Considering this situation, I don't suppose you'd have any trouble with us holding this case until after the family court proceedings and then getting a report from you about what occurred.
I don't. I think that would make sense, and I'm happy to submit.
A post-hearing submission?
I am. My only concern with that, Judge, as you know, in this case, and I had hoped the court might emphasize in its decision, if the court agrees with me, that the importance of permanency in these proceedings it was, in my opinion, overlooked in this case. We had a petition filed in December of 2019 and a decision issued in September of 2023. So my concern is that while it's scheduled for trial on March 17th, it could be a year before the trial concludes. It could be months after that before we have a decision. So I would go ahead.
We currently have an order that the petitioner has custody in a situation where the petitioner is not even seeing the child.
That is correct. There is a temporary order that places my client with Miss Yukanda Perry, who is not a party to this appeal. There's a complete breakdown in my client's relationship with the original petitioner in this matter, and there is no contact.
Okay, and I'm assuming that the family court case will resolve that. The placement of the child.
Some sort of order, whether it's with Miss Perry, Miss McFarland, or a shared arrangement. My expectation based on my communications with the trial AFC, my client, and the parties to that action are that it's going to be resolved on stipulation. But if it does go to trial, it could take years for me to get a post-trial submission to you.
So we have a non-appearing petitioner. We have separate AFCs. We have a child who's not where she's not supposed to be, other than a temporary order. But do you feel that moots this case out? What was the family court judge thinking when was the family court judge aware of this appeal?
I assume so. There's been communications with my office, and the mother in this appeals council has also communicated with the court regarding getting copies of that temporary order and status of proceedings. I can't.
And why does it take a year to decide? That seems kind of extreme.
Especially you seem to think it might be resolved by agreement.
It could be, but as I referenced, this underlying matter that's on for appeal took 4 years to get a decision. So, it is a concern. It's not a novel concern in regards to family court. And I can't promise you that just because it's scheduled for trial on March 17th, that I would have any sort of substantive post-trial submission for you on that date or any time in close to that date. I'll do my best.
I take it the concern might be that if it does take long, if we don't have a stipulation soon, child needs medical treatment or something, you might have a hospital looking for a petitioner because the petitioner is the custodial parent and petitioner is not involved. So that's the issue that we have to address.
Yeah, I believe the temporary order that's currently in effect gives the maternal aunt, Miss Perry, the ability to make those decisions, as she does have temporary custody of my client. But of course, it is a temporary order.
And you're probably the wrong person to complain about this too, but we don't even have that. The temporary orders. Last thing we had is an order that gave the petitioner custody. And, there are a bunch of rules. And like I said, I'm not sure you're the person who needed to fill us in, but, we're supposed to know about subsequent orders that affect the matter on appeal. And so.
I understand. If I could have gotten a copy of that order, I would have provided it in advance. It is tricky because I'm not a part of the underlying matter.
We'll figure it out, counsel. We'll figure it out.
Yes, I will keep tabs on the trial court proceedings, and I will update the court if and when I'm able to do that. But I understand that the current proceedings may moot this appeal.
Very good. Let us know. Thank you very much.
I will. Thank you for your time. Have a great day.
Bye-bye. Okay. Case number 165 is submitted. All right, case number 166, 167, Smith versus Jordan Elbridge. Have a seat. Okay, counsel.
Morning, Jared Smith representing the plaintiffs. Your Honors, I'd just like to start off with what needs to be contained in a notice of claim. Notice of claim has to be location, facts and circumstances supporting whatever grievance you may have against the entity, in this case, the Jordan Elbridge Central School District. It has to maybe time of when it occurred. These issues were handled in 2 letters, January 21st of 2021 and November 29th of 2021. At that point, once those were filed, and each was given a decision by the Board of Education, there's 2 avenues plaintiffs can go. One, you can make application to the Commissioner of Education and have that dispute decided by them, or you can go to a court proceeding. Because there were children involved, CPLR 208 is invoked. It tolls the statute until their age of majority, which is 18 years.
But we still have you and another adult as plaintiffs on this case.
Right, but the allegations within those 2 letters were about children.
What I'm saying is, are you expecting this court to toll the statute of limitations for you and your wife?
Oh, no, no. That would be inappropriate and improper. That's not the case here.
Okay,
The
so
case-
you're asking that we recognize a toll for the children.
Yes,
Okay, and also in doing so, recognize that the school system had notice of all the essential facts that would have been in a notice of claim.
yes, Judge. And with that being said, they rendered decisions on those 2 letters. One was in writing with an email, which was part of.
They rendered decision.
They denied the applications. That's a decision by the Board of Education. One was in an email, one was in a phone call with one of the other plaintiffs in the case, which was the mother.
I mean, those administrative proceedings that you pursued.
We didn't. We elected to pursue court.
The one concern, I think the court raised it with respect, but it goes certainly to the heart of the 2 letters. You have, I think, 2 pieces to the notice of claim, maybe more, but 2 pieces that are relevant here. One is there are these underlying facts that happened on a date in the past. And there you say, we gave a lot of notice as to dates, times, events, exactly what happened. I don't know if I disagree with you there. I don't think I do. But the other aspect of it is the purpose of why we're giving, in this case, the board, the information. Is it because we're going to bring a claim? Well, that's the notice of claim. Or is it because we have another avenue? And here it seems that the 2 letters had other goals, other aims. One was to stop the appointment of a coach because you didn't think the person was qualified.
No, they were
the other was a request to say, well, we'd like to try to make sure that our child is able to play this year. And so it seemed to me that there may have been a different purpose. And is that sufficient for the notice of claim?
I think it is, Judge, because if you look at the case law and you look at the section 50 of the general municipal law, you don't, first of all, it doesn't have to be, and I think the lower court totally relied on that it wasn't labeled a notice of claim. They couldn't get over that hump, that it wasn't labeled a notice of claim. It doesn't have to be. A case was cited where a contractor presented their grievance in a letter, didn't present anything about damages. It was inferred that they were owed money. That's a notice of claim. And on top of that, this school district, not for us, but others that I represented, would give out the avenues, the fork in the road. You can either go to the commissioner or you can go to a court. And at that point, we decided to go to a court. And our position is that was told for the children, not necessarily for the adults in the matter, but for the children. Now, if you go further on, there was another notice of claim filed in 2023, then an amended, which I don't really consider the one that was filed on April 20th. That's nothing anymore because there was an amended done. The school district never objected to the 2 letters, the service of them. They were timely filed. They never objected to the notices of claim further on in 2023, which just listed
all the information that was in those two letters.
Your position is that they had actual notice regardless of the form of the notice of claim.
Exactly.
Is that correct?
Exactly. And that's the purpose, I think, your honors, of the statute, is to give notice to public entities to do the proper investigation. And they did. We had 5 50H hearings ranging 6 to 8 hours. I've stated case law in there. They waived all challenge to the notices of claim at that point. Under 50E3C, they waived all the service requirements. They were all timely filed, and they were told for the children.
Is there anything in the record that says that they were reserving the rights when they granted the 50H hearing or held it with regards to the children? Is it not anywhere in the record?
Not that I recall. If it was in their notice, possibly, but I don't recall. But we did 5 50H. 6 DASs were filed. They had plenty of notice of what was going on here. So when we did the 2 letters, those letters were their notices of claim.
So it would be up to us to read them and determine whether they gave enough notice to the defendant about the case that you'd like to present.
And my brief also addresses that each of those letters raise a causable causes of action that are placed in the complaint.
Okay.
So
I think we understand your position, Cal.
thank you. Thank you very much.
Good morning, Your Honors.
Morning.
Rick Weber, Bond Shutting King on behalf of the respondent. I think I'd like to start picking up on a comment that Justice Nowak had indicated. A statement of events is not in and of itself a notice of claim. A statement of subjective dissatisfaction with a situation is not a notice of claim. There's no argument here that the school district had received a number of letters, none of which were captioned or indicated in any way that a claim was forthcoming. What they indicated was a list of concerns. It was an interaction with the school district. And in fact, at paragraph 17 of petitioner's brief, concedes the correspondence are not verbatim pre-statements of the causes of action. All right? The court has accurately picked up the 2 letters that are cited after the fact and are being rebranded. Yes, Your Honor.
Thank you. The January letter regarding the appointment of the individual as the basketball coach. You know, I think that is a little bit more far afield. We'll talk about the November 21 letter after, but isn't there still, even with the January letter, an expectation that there's going to be some sort of an investigation? You're considering making an appointment. We're giving you now these facts. We think you should look into our facts in order to see, again, whether a different purpose, but the issue is, are they going to do an investigation?
The different purpose is the key issue. They are not going to, that is not being written for the school district to do an investigation into the underlying facts of what may have happened to the infant plaintiff JS. That's being written to say, we want you to investigate whether this individual, Coach Ahern, is fit to serve as a basketball coach. Very specific purpose. So there's not anything there to alert the school district in that letter. Hey, regardless of what happens with Coach Ahern, I'm about to sue you.
They could take that letter as factually true and just move on from there. But the later one, the November of 2021 letter, it seems to me that one did ask you to verify that our child was bullied. And so that does essentially call for more of an investigation.
But the context in which it asks for it asks in that content to verify that the child was bullied, so that child can then secure a waiver from Section 3 athletics to participate in high school sports. That is not an alert that, hey, we're about to sue you. And in fact, ethically, that couldn't have been an alert to say we're about to sue you. You give me this waiver or I'm going to sue you. Is that really what this court wants to send as a message? I don't think so. There are ethical candidates that prevent that.
To alert you to the facts of what happened. And that's what he's doing there.
To Justice Nowak's
to the, okay, but I'm not talking about Justice Nowak's points. I'm talking about what Mr. Smith did in this particular case. And didn't he notify the school district about his daughter being bullied to an extreme, examples of it?
The premise, first off, all this court needs to know about how confident the plaintiff was in those letters was the fact that in a verified pleading signed by both Jared Smith and his wife, they told the court and the parties that the notice of claim was April 2023. And then they told the court that they amended it. So in the verified pleading, they told the world, we gave notice of claim in April of 2023. Now, when we raise that notice of claim is late, they start thinking, what can we do to recast earlier communications? And let's be clear, the theory that's being articulated by the appellant's counsel in his brief goes way beyond any jurisprudence of this court. I direct the court to 21 of 29, where opposing counsel is asserting, I've been known to sue school districts. So because I've been known to sue school districts, quote, did not have to explicitly threaten legal action. It was by virtue of what plaintiff Jared W. Smith does for a living that it is an implied promise that a lawsuit was coming to protect his own children. That's the starting point. The starting point is, as an attorney, any communication you make, anything, indicates that a lawsuit is about to come. And that's just absurd. And if you doubt this, let's look at it.
Let me ask you a question.
Yeah.
Let's assume, for argument's sake, that what Mr. Smith did here was inartful, to be generous, okay, with the school. But that's not what this court has to decide, is it? Don't we have to look at the facts of what happened? And I mean, if he labeled something a notice of claim and it's not, that doesn't really matter, does it? Doesn't it matter what was communicated to the school district, whether it was either a notice of claim or whether you had actual knowledge? Isn't that really what we have to decide?
Justice Greenwood, respectfully, it has to be enough to put the school district on notice that a claim is coming. So when a letter.
In that regard, you got evidence that a notice of claim is coming, maybe. I mean, apparently there were 5 50H hearings, which apparently you or your client had requested, correct?
Oh, yes. There's no 50H hearings. That's correct, Charles.
So, I mean, generally you would hold a 50H hearing when you perceive a notice of claim has been filed.
You bring a 50H when you perceive a notice of claim has been filed. That is
here, but here you're saying there's no notice of claim that's been filed. You didn't follow the requirements. You didn't label it correctly. We don't know what this is all about, but we're still going to request 5 50H hearings.
We're saying there was no notice of claim brought until April of 2023. And not only are we saying that, the plaintiff in their original verified pleadings are saying.
So taking that as true, does that notice of claim untimely?
Yes.
For the children?
Yes. We would assert the notice of claim is untimely, that the lower court got that right. And in any event, if you were to extend that further, a claim of any kind right now would be untimely. I mean, look, in the record is the date of birth of JS, right? JS is now 20 years old. So for the last 2 years, JS has been an adult who could choose her own destiny on this case. I haven't seen anything.
JS in 2023 when.
Well, 2006 birth date. So at the time of 2023, she would have been under 18, Your Honor.
Okay, and that's when you actually got a formalized notice of claim, labeled notice of claim.
The formalized notice of claim, first formalized notice of claim that showed up was April of 2023.
Okay, when JS would have been under 18.
Under 18, no longer in our school system, but under age 18, yes.
And that together with notice of the essential facts of what they're claiming was done to their child by your client. You don't think that that's sufficient to have this case go forward?
I do not. And the problem is not, necessarily the factual allegations. The problem is a procedural allegation. The jurisprudence under general municipal law, section 50, indicates what has to go into a notice of claim. And one of the first things that has to go into a notice of claim is notice that a claim is being made. That notice was not made until April of 2023. There was notice that they objected to a coach as a basketball coach, and maybe you should look into these allegations to figure out if she's fit to be a basketball coach. And then there was a request after the transfer, after this kid had departed from the school system, to say, wait a minute, we want you to support our waiver application to Section 3 athletics. That's not a statement that I am suing you, that there is an active claim going against you. There was no.
What's the point of having a 50H hearing if you're not gathering information about a potential claim?
Well, part of the issue of the 50H hearing is when a notice of claim rolls in, you have the right to a 50H. The case is not in suit yet. You do the 50H to determine whether there's any basis or frankly, anything to talk about before the case goes into suit. We did our 50H. In the 50H, we confirmed various dates and times. We confirmed what their allegations were, among other things. There's 50H testimony from opposing counsel himself indicating that at the time of the letters, he was trying to work through things with the school district. He was intentionally not trying to make a lawsuit.
Is there a reservation of rights as part of the 50H or in the record somewhere that you weren't conceding that there was a properly filed notice of claim?
I'm not certain that there is, but nor am I certain there has to be. The verified pleading.
I'm saying there has to.
I understand that. The verified pleading that ultimately came in said, notice of claim timely, April 2023. Now, I didn't say that, and I didn't say that under oath. But the appellant and the appellant's wife did. They said, this is timely. And it wasn't until we had gone through the 50H, we had done the examination, they had brought a complaint, which was a 60, 70 page complaint, 24 counts of action. It wasn't until they had done that and they were confronted with our motion to dismiss that they said, oh, geez, wait a minute, we might have a problem here. And now they go back to try to recast first the two letters. But then if you look at their brief, think about everything they're recasting. Emails, internal documents, DASA complaints, any communication between the appellant and the school district, they now want to recast as notice of claim. Think of how broad of a standard that is. That would eviscerate the general municipal law entirely. We had a right to do a 50H because a notice of claim came in. It's that simple. We did a 50H and we documented through that 50H that we did not see earlier specific notice of claim, nor was there any claim in the 50H testimony that they had previously noticed this matter. This didn't arise until the motion to dismiss. The one other thing I can see you're nodding, Judge. I won't take too much more time, but I do want to note for the record, this is a strange two-parter appeal. It's two different appellate numbers. The second number relates to the follow-on motion to re-argue, of which the lower court issued a letter decision that dismissed the motion to re-argue. You've got our position in our brief. We don't think an appeal lies from a motion to re-argue. To begin with, in short, we think this court should affirm the lower court.
Thank you so much, Counselor.
Thank you.
Okay, case number 168. Balboa versus the City of Auburn. Morning, Counsel.
Good morning. May it please the court, Charlie Roberts for the City of Auburn. There's a number of issues. In the brief, I'm just going to address the primary ones, and if the court has any questions, I'm happy to address those. The primary argument that we put forth here relates to the failure to comply with General Municipal Law 50H. Just briefly, the timeline here is 2 days before the scheduled 50H, council asked for an adjournment so he could attend. That was adjourned. The day before the rescheduled date, council advised that the criminal matter was pending, excuse me, and invoked the Fifth Amendment right against self-incrimination and requested a second adjournment. My former colleague responded and confirmed that the 50H was canceled pending resolution of the criminal charges and quote, "It will be your and your client's responsibility to contact my office once the criminal matter concludes."
The Kemp case that you're relying on.
Yes.
I think second department.
Correct.
It My recollection of that is that they essentially show up at the fifth privilege, ready to go, and that's when the privilege essentially is made by the claimant saying, yeah, I'm essentially taking the fifth on this until my criminal trial.
Right.
And so is it different when you call ahead of time and say, we're asking for you to consent because we anticipate that's going to happen? Is that different?
I don't think it is, Judge. I think what the issue is the underlying cause. And so whether you do it when you're sitting down and the person takes the fifth every question, or you have a courtesy in the day before and say, we're not going to show up because we're taking the fifth. The underlying cause is that the person is asserting the Fifth Amendment, and so they won't be testifying. So when the underlying cause is on the claimant, that's when the case law puts the burden back on the claimant to then reschedule. And that is consistent with the instructions that my colleague provided to the claimant in this case. And then the guilty plea to disorderly conduct came in May of 2023, and they didn't notify my colleague or the city at all and didn't make any attempts to reschedule. And then they filed a complaint on January 4th, 2024. And so I think the issue is the cause. And the other case that is more recent, Landa versus polling cars, it's not a Fifth Amendment case, but it's a decision of this court where it put the burden on the claimant to reschedule the 50H. And I think that's consistent with other cases well, really across the state, but Fourth Department, it's the Klaczynski matter as a 29th decision. And as you mentioned, Judge, the Kemp matter and the D. Pompo decision that's in our brief. The claimant and plaintiff now and the lower court seem to focus on this Torsivia decision, which is a federal court decision, but that court, it's being misread. It's in footnote 19 of that decision, where the court goes on to distinguish all of these cases, where in every one of those cases, the plaintiff, not the municipality, was the cause of the adjournment or postponement. And so that I think the case law is very clear that when the underlying cause is the plaintiff and specifically asserting the Fifth Amendment, whether it's the day before or at the day of the hearing, it's the plaintiff's burden to go back and reschedule that. Quickly on the notice of claim itself, it talks about excessive force. There's a typo, a handwriting error in the claim, but that isn't sufficient for the other claims that they've asserted, the negligence and negligent training. That's this court's decision in Odell is a 2019 decision. That was a false arrest, but they didn't include sufficient allegations for the remainder. I'd note on
Counsel, page 18 in the record is the form, the notice of claim form that it looks like it's a city of Auburn form because it says that it gives you the address where to send it. It makes it a little bit easier for folks to fill out.
Right.
There's only 3 lines on the form for description of occurrence. In this case, the claimant used 4, went into the little space between the 3 lines and then the next question about the injury of damage. So, you know, she went beyond the space it provided, but it seems to me that you're suggesting that she should have like perhaps attached another sheet or something, or that I'm wondering if maybe the form didn't quite give an opportunity to the claimant.
Well, I don't think the municipality has an obligation to provide instructions and opportunity to a claimant. This is for convenience. It states right on it, this form is supplied for convenience of the claimant. The use of this form shall not be deemed a waiver of any defense available in the city of Auburn. As to the form or otherwise, please refer to General Municipal Law Section 50E. You know, and so
you're saying that that information that was supplied was not adequate for you to perform an investigation of these claims?
I'm saying it was adequate to inform an investigation of the excessive force claim, but when you go beyond that to the negligence claims, my point on that was just to the negligence claims that they've included in the complaint. But I want to reiterate my main point here is that without the 50H hearing, the entire complaint against the city should be dismissed.
Okay.
Thank you.
Mr. Hooper?
May it please the court. My name is Justin Huffman. I'm here on behalf of the respondent, Leslie Villalba, who is here in the courtroom this morning. I am asking that the court affirm the denial of the defendant's motion to dismiss. I believe that the case law is clear that this matter is not subject to dismissal for failure.
Did your client cause the adjournment? The reason for the adjournment?
Your Honor, I believe the parties agreed to the adjournment because I did reach out and explain the situation that because she had a pending criminal matter that was related to the events that gave rise to this notice of claim. And as a result, it would quite frankly be a waste of everybody's time because she would likely be invoking her Fifth Amendment privileges.
Did you then discuss whose responsibility it was then to reschedule this 58 hearing?
I believe it may have been, a comment may have been made in an email, but a full discussion hadn't taken place.
Didn't that comment say that it's going to be your responsibility or your client's?
I believe the email cited did say that. I don't necessarily agree with that conclusionary comment. But at no point did Ms. Villalba ever refuse to appear. At no point did anybody reach out and say, hey, it's been a few months, wanted to touch base on our 50H demand. We'd like to reschedule it if the matter's concluded. At no point did that ever take place. So yes, the matter did conclude in May of 2023 with a plea to a non-criminal violation level offense. And as a result, and there was no communication afterwards. And next thing, and all of a sudden, here we are, we're coming up on the 1-year statute of limitations. At no point did Ms. Villalba refuse to appear. At no point did we say, no, we are not producing her, period. The rescheduling just simply did not happen. So she did not refuse, she did not fail to comply in any way.
Opposing counsel says it's on you. It was up to you to reschedule.
I do not believe that to be the case because again, the parties did mutually agree to the adjournment and for whatever reason that just did not happen. They did not reach out. We did not reach out.
So I have another question. In the record, it appears that there was supposed to be some kind of a traverse hearing with regard to the service. Did that ever happen?
That has not happened yet because the parties did agree to essentially wait for the ruling from the Appellate Division.
But that puts us in a little bit of a weird place because let's say there's a decision that no service was properly made. You know, why would we go through this exercise if that issue would be dispositive of everything?
And that may be, Your Honor, but quite frankly, the matter that was served by somebody who worked in my office, and we had the conversation, and I'm familiar enough to where I'm comfortable with the fact that she did properly serve them.
But you understand our predicament. We have an issue hanging out there that for quite a while now, that would be dispositive if it went against you. We wouldn't have to address any of these things.
Certainly, I do understand the little chicken before the egg type of situation there, but like I said, an employee at my office, not my employee, but a business partner's employee did effectuate service, and I'm comfortable with that. I was personally comfortable with it.
Okay. All right. Anything else, Council?
Otherwise, I just want to point out real quick that I know they made reference that we had conceded any points in the brief. That simply did not happen. We addressed each of those points, albeit very briefly, because I think the complaint and the notice of claim were very clear that Ms. Villalba did in fact state sufficient cause of action here.
Okay.
Bottom line is, on a routine traffic stop, she had 4 police officers slamming her head against the hood of her own vehicle.
We understand the allegations.
Certainly, Your Honor.
Thank you, Counsel.
Thank you.
All right, case number 169, Robert Owen Leman Foundation. Counsel.
Good morning. May it please the court. I'm Claudia Jaffe for appellants, the Rieger heirs. Under New York law, the right to maintain a cause of action for recovering property of an estate belongs to the personal representative of the decedent's estate. Succession to a decedent's property is governed by the law of the country where the decedent was domiciled. Under Austrian law, in intestacy cases, the only persons who can inherit are blood relatives and the spouse or domestic partner of the decedent, provided that they first get a probate decree. Respondents failed in their burden to show they obtained an heirship certificate concerning Carl Maylander, so they lacked any legal interest in this drawing. As a matter of law, the trial judge committed reversible error by failing to consider the Austrian law, which the Rieger heirs presented during trial. As a matter of law, furthermore,
Did the court fail to consider it or did it reject it?
the court failed to consider it. We offered a rebuttal affidavit of Mr. Gruber that included a.
Well, that affidavit of Mr. Gruber came a little tardy, wasn't it? A little bit late.
No, Your Honor, it was.
Tried to offer him as a rebuttal witness, maybe the last day of the trial, close to that.
No, Your Honor, respectfully, that wasn't the case. The Zirkle defendants presented witnesses on day 2, 3, and 4. On day 3, the witness, Mr. Natter, said, "We heard we might have a drawing because somebody called us." And we were starting to wonder, do they have an heirship certificate? On the next day, we asked the witness, Mr. Natter, if he'd seen an heirship certificate.
Wasn't there also evidence from your opponents with reference to, I think it was a Professor Graff, who indicated that this heirship that you're talking about was something that was not a direct requirement?
So Professor Graff, so if I can back you up for a second, Your Honor.
Sure.
So we filed actually after day 4 of the trial testimony. When they seemed to stop, they had called the 3 witnesses and they stopped. They didn't rest, but they stopped. And we spotted this issue. Court was not in session on that Monday, but we went ahead and notified. I personally emailed the court's staff and counsel to tell them about this issue about the heirship certificate. So that's after day 4 in a 13-day testimony trial.
But didn't you admit, your clients admitted it, and at one point in time, in judicial admissions with respect to, yes, the Ezekiel our individuals, our defendants, or our trust is an heir to Carl Maylander?
No, Your Honor, we did not admit. There was no request to admit, sir.
Seems like it was, the court found that you admitted.
I think
Your answer.
No, I believe, Your Honor, that the court said its objection to us offering the testimony on the Austrian law through Mr. Gruber and Dr. Hofer was that it thought that we waited too long to do so. That was how I understood the gist of the court's decision. But we did not admit.
It seems like it started in 2006 is when the dispute sort of arose, so there's quite some period of time where this could have been brought to your attention. I mean, there was, as far as there was, obviously litigation with reference to whether or not the Zirkles or a listener had proper standing or to bring this action or claim to this artwork.
In the case, the parties became aware of each other in 2016. The case was filed in 2019 by Mr. Leman. These folks never served a complaint against us. Therefore, we had no pleading that we needed to respond to or possibly waive the right to do it. We did not have an obligation to disclose a rebuttal witness because the trial court's bench trial order on NICEF number 1113 from January 29th said, no impeachment and no rebuttal witnesses need be disclosed. Just give me your primary witnesses. So it was not late. It was on rebuttal, and the need to call these witnesses and introduce the supporting information under Austrian law came up because they failed in their burden in chief in their case. They had no right to be in this courtroom because they are not the legal heir. And you spoke, Your Honor, Judge Montour, about what Professor Graf said. Professor Graf did not even look at the Austrian intestacy law. He recited provisions from Chapter 500 of the Austrian Civil Code, the ABGB. If you look at Dr. Hofer's opinion, or even the code itself, and I provided links in our brief, you have to get a declaration from an Austrian court. You cannot automatically become an heir in cases of intestacy. And furthermore, in this case,
Wasn't there a number of other instances where the Austrian government deemed Eva Zekel to be an heir of Mainlander?
not quite, Your Honor. So
And again, I think there was also a situation where your client, I'm going to say your client, with reference to, what's her name? Elizabeth, yes. No, it was Elizabeth. Where she had to remit a couple of the artworks from her collection. Leopold, they had to remit some, I'm using the wrong term, remit, but a couple of pieces of the Mainlander that were in Leopold's possession.
So I'll go to your first.
So again, how many instances are there where the Austrian government or board has indicated that Ms. Zekel was an heir of Mainlander, therefore entitled to return of the artwork?
Couple points on that. The Austrian government did not deem her to be the legal heir. The only one who can deem her to be the legal heir is
Maybe I'm using the wrong term. The government,
No.
it's a board of advisors, a board of.
It's the right term, and counsel was the one that used it before you in the papers, essentially. Sum and substance. They did not deem her to be the heir. The only party who could deem her to be the legal heir is the probate court after probate proceedings. Probate proceedings were not held. What happened here is they got a letter saying, Chris, we've got a book. We don't know whose it is. Do you want this thing? It has no value. So the IKG, the community organization in Vienna, says, oh, you might be the heir. And they say, okay, what do you mean? Have the book. And they say, okay, well, we could hire you and you can look for more stuff. And the IKG says, okay, this lady is the heir. The IKG is not a probate court. They never went to probate. They never got any legal authority. And under Austrian law, which this court is required to apply on intestacy matters, under Austrian law, they have no right to be here. Secondly, the court talked about the return by Elizabeth Leopold. So what happened was, it was an advisory board who looked into the issue after the IKG made a big stink and put crime tape around the Leopold Museum. And they said, what do you want to do? The Austrian government has a museum, the Albertina. Albertina says, have at it. There's a few pictures, go have them. They didn't dispute it. Okay, so there's no dispute there.
Who did dispute it?
Albertina Museum had pictures, and they didn't dispute that these things belonged to Mainlanders. So certain things went back voluntarily, but not by a court decision, not by a government official thing. And the letter that this council refers to from 2011 says, on the quote, assumption that Eva Zekel is the heir, you can give away what you want. We don't mind. If you want to give it back, okay. The Leopold Museum was asked to consider returning 5 pictures. They didn't, but they gave back 2 of them. Elizabeth Leopold did. But there's no determination that they did so on the basis of a probate court saying that Eva Zekel is the
I
heir.
think I understand your position on that.
Thank
What
you.
else?
I'm sorry, just one more question before we move on to the next thing. The timing of all of this. The Zekel defendants answered in January 2020, and while they didn't assert cross claims against the Rieger defendants are part of the action. They see what claims are being made by the Zekel defendants. They did assert counterclaims to reclaim the artwork. So at that point, the Rieger defendants are on notice that the Zekel defendants are making a claim here. And so the time, I think, to at least raise the standing issue may have been right then. The Rieger defendants did answer a couple of months later, May 2020. They brought cross-claim for a declaratory judgment against the Zirkle defendants, but didn't challenge the Zirkle defendants' standing. From my review of the supplemental record, page 109, is that the waiver? So even if you say, well, gee, under Austrian law, that's a good claim. That's a claim that they shouldn't even be part of the lawsuit, which I think is how you phrased it a few minutes ago. Was it waived back in May of 2020 when the Rieger defendants brought their claim but didn't assert standing?
No, two reasons. We didn't know that they didn't have their goods. We didn't know that. And the issue of not having this airship certificate is a jurisdictional one. There's a World Trade Center case on that point, that if you don't come here with the ability to bring the case, you can bring that up at any time. But it's not for us to do. And in our pleading, responsive pleading, that we did have an obligation to serve because we were served by Rolf. When we responded to that with respect to question number 12 or allegation number 12, which talked about ancestry on their side, they claimed to be that Eva Zirkle had been the ancestor, that Carl Maylander had been the ancestor of Eva Zirkle. We DKI'd that. We said, we don't have knowledge or information of that. That's taken under New York law, DKI as a denial. So we denying their ancestry. And furthermore, Rolf, in its answer to the Maylanders complaint, denied knowledge as to that same point. So the issue was preserved. It was not waived by anybody in this case. Your Honor, I was speaking earlier about the errors of the trial court. As a matter of law, the trial judge committed a reversible error by failing to consider the Austrian law that we pointed out earlier. As a matter of law, again, the trial court committed a reversible error by giving rights in the drawings to someone who failed to establish they ever had an airship certificate, and therefore there was insufficient evidence to give them any rights in the drawing. As a matter of law, the trial judge committed reversible error in denying our motion for directed verdict and awarding the drawing to anyone but the Rieger heirs, because we had an airship certificate and we made a threshold showing of an arguable claim to superior right of possession in the property. These are legal errors subject to de novo review.
Did you prove that you had rightful ownership to 1908?
Yes, Your Honor, we did. At the end of the day, to cut it short, because I know we're going to run into time issues, but at the end of the day, we are the only party who had right to be here as between these claimants.
But even if say you had a right to be there, but did you prove the fact that Rieger had at one point in time D 1908?
Yes, Your Honor, we believe that we satisfied our obligation on that to make that threshold showing. We had a 1921 Austrian government BDA property list of Dr. Rieger's property, and number 300 on that was the portrait of the artist's wife by Sheila.
That's the oil painting, right?
No, it's not. Actually, it specifically says on the list aquarelle, meaning watercolor.
Mm-hmm.
That was 1921. In 1928, and this is probably the best part of the story. In 1928, there was an exhibition coordinated by Otto Nierenstein Collier. He was the proprietor of the Neue Gallery, and he organized an exhibition 10 years after Egon Schiele's death. It was at the Hagenbahn building and at the Neue Gallery, and a third site, the Worthla Gallery, and at Maylander's apartment, he did his own business. But in connection with that, this article came up. This is Parnassus Magazine. And Parnassus Magazine talks about this tremendous showing. It talks about how Otto Nierenstein organized it 10 years after Sheila's death. So we know it's this
I think
specific.
the court indicated that was recently. No, so
Yeah,
it didn't say it was. So it didn't say it's that one. It didn't say it's Rieger's. It didn't say that, it was actually at this point in time it happened was recent. Maybe it was 2 years before. Maybe it was something else. Maybe it was in the 30s, but no evidence of that.
The trial court may have said that, and counsel may have led the trial court to utter those words, but the court was mistaken if it did so. If you take a look at that Parnassus Magazine article in page 1919 of the record, you see the big picture, and it says portrait by Egon Schiele, recently shown, as you mentioned, Your Honor, recently shown in the Neue Gallery in Vienna. But then you go up here, and it specifically tells you that it's 10 years after Egon Schiele's death. Egon Schiele died on Halloween 1918, the Spanish flu epidemic. So this is October, November of 1928 is when this section of it started.
Does it have a Rieger stamp on there?
This is a magazine article.
No, does the artwork have a Rieger stamp on there anywhere?
No, it does not have a stamp, nor is it.
Rieger did. We know he's put his stamp on.
No, he didn't always, Your Honor. And neither does it have a Maylander stamp on it.
Well,
that's why we're here. Okay.
There's a contract from 1960 referencing
There's a contract from nineteen
So
sixty.
number 5, and number 5 was D 1908, right?
No, number 5 is a portrait of the artist's wife, a portrait of Edith is how it was described, and a handwritten contract. But there's nothing that says that that drawing was D 1908. This, on the other hand, pictorial evidence, we have it. You know, in those days, you didn't have video cameras and cell phones showing everything.
Pamphlet, isn't it? It's a pamphlet showing a
It's a magazine article, like you might get the New Yorker and
Right.
tell you what's playing on Broadway and what's at what museum. This is telling you what's at the Noya. And then you look at other supporting documents that tell you whose stuff was at the Noya. And we have,
wasn't there more than just Rieger stuff?
no, there wasn't.
Okay.
Bear me
Court's
out.
decision doesn't say that?
The courts, I think, perhaps might be ambiguous or whether there is or whether there
I
wasn't.
think I read it again last night. It seemed to be pretty particular.
Well, then let me
that
point to-
reference to like 5 or 6 other artists that were there.
No, it says that there were loans
Okay,
made.
maybe I misread it. Thank
No, you may not have misread it, but the court may have misstated it. My friends here made a comment that there were other collectors who loaned in connection with the overall exhibition at the multiple sites, okay? At the Noya, the only collector whose works were identified as being there were Heinrich Rieger's collection. And specifically, counsel has said before, the articles don't say it was the only collector there. That's their big point. It's the only. But actually, if you look at one of the documents that their witness discussed, they do basically say only. If you look at the record, page 4669, there's an article called 3 Times Sheila. And Mr. Natter identified the author of that article as Max Rodin. The judge identified Max Rodin as a collector of Sheila's, prominent collector identified in Sophie Lilly's works. Max Rodin says, if I may quote, "The exhibitions at the Hagenbund and Noya are dedicated to Sheila's memory. Regarding the latter, the Noya Gallery, quote, it includes most of the works owned by the collector, Dr. Heinrich Rieger." That's one collector named. Continuing, hence, what is on display naturally stems from a very specific attitude of the collector. And then he references the painting P316, which Mr. Natter also identified in direct and cross-examination as being the one you mentioned, Your Honor, the oil painting, the famous oil painting at the National Gallery. So we have different perspectives coming together. We have the Parnassus magazine that gives you a visual. That's the video camera, in effect. This picture was there. We have catalogs that only identify Dr. Rieger as the collector whose works were shown, as compared to the Hagenbahn, where you have 80 works and multiple lenders. And also on the point about other people lending, I have in our evidence, we have evidence that watercolors went to the Hagenbahn as well. And Christie's identified watercolors as being inside cabinets at the Hagenbahn. So they've also brought up Fritz Grunbaum's collection. The Grunbaum family was represented by my firm. We know those documents well. Grunbaum only lent to the Hagenbahn. Mr. Nierenstein was the guy running the show. So he says, yeah, can we borrow your stuff? And Mr. Grunbaum says, yeah, tell me what you want. Go to my apartment and look it up. And he has a whole list. We have receipts saying watercolors returned from Hagenbahn. So works that were lent to the exhibition were in primarily 2 cases. Rieger's at Noya, and nobody can say boo. There's nothing else, nobody else presented. And the other location, primarily oil paintings, but some watercolors and some graphic works. So there's no there, Your Honor, respectfully. If I could just.
You should begin to wrap up, but.
Yeah, thank you, Your Honor. I just want to touch on the latches point, if I may. The court used the wrong standard there. He used a constructive knowledge standard saying that the Rieger family should have figured out earlier that Leman or Rolf had it. That's the wrong standard. That was from Bacalar. That's changed by the HERE Act. Actual knowledge is required. That alone requires a vacatur. Secondly, the Riegers' history of searching for the artwork is demonstrated. The Portrait of Wally case talks about how the Riegers were searching and searching. There was a mix-up as which picture was the portrait of the artist's wife. So that's documented. Claims made in the mid-1940s, claims made to U.S. military and Austrian restitution authorities, records in the archive saying Frederick Wells kept the collection. That was all publicly accessible if Mr. Leman or Rolf wanted to look for it. And laches is supposed to be an equitable bar based on a lengthy or unconscionable delay. Rolf got this artwork on March 29th of 2016. It got the notice of the heir's claims 2 days later. So there's no delay, no unconscionable delay, no prejudice. But mostly I just want the court to understand that the whole idea that there could be a laches claim here is just incongruous. What the court says on 5 pages, all the efforts that the Rieger heirs undertook to try to find this artwork and assert the claim. Your Honor, if the court has no further question, I'll close with that, but just ask that the court enter the award for Rieger and if necessary remand for entry of judgment. Thank you.
Thank you, counsel.
Good morning. I want to.
Why don't you go into standing?
Yeah,
Why,
I want to start with
why,
this.
why are you here? Are you supposed to be here or not? You know?
We are supposed to be here.
Who let you in the door?
I'm sneaky. At least according to my friend here. I think there's 4 different arguments. I'm going to just explain what they are and then I'll go into each. The first is that I don't believe this is the Rieger's argument to make. I think this would have been the Ralph's argument to make, and I'll explain that. The second was that this is supposed to be raised at the earliest possible time, which I think you alluded to, Judge Montour.
Right, I'm looking at page 31 of your brief. And
Yeah.
you have a block quote from the court regarding CPLR 3211A3.
Yep.
And it says here that any objection or defense based upon any of these grounds, which includes standing, is waived unless raised by either such motion or in the responsive pleading. And then the court goes on to talk about the answer and how they didn't raise the issue of standing in the answer.
That's right.
So you would disagree with your opponent with respect to whether standing is non-waivable, that it is waivable under this section.
Correct. It is, yeah, and I think it was the third point that I'm going to, and I'll try and get to that in a little more detail. The third point is that the argument, this was a rebuttal witness. This wasn't a rebuttal, and I'm going to explain why, but not only wasn't it a rebuttal, this wasn't new evidence. And the fourth gets to the point that was discussed too, which is even if all those 3 reasons are wrong, my adversary is wrong on the merits. I want to go back to the first point though, about who gets to raise this issue. The possessor of the artwork was the Leman family, and they gave it to Ralph, and the Leman family sued both sets of heirs. We obviously, on behalf of the Mylander heirs, filed the counterclaim, I think is noted for replevin, which is what we were required to do. The Rieger heirs did the same. The Rieger heirs took the next step of also cross-claiming against the Mylander heirs. But the point is, if there was no standing, this would go back to the Lemans and to Ralph, who hasn't appealed, who never challenged standing and didn't appeal. Right. So there's no one to go to. And interestingly, even if it were reversed, I'm not sure who this would go to. I guess this issue would then be tried again. And that's the reason you're supposed to raise this at the beginning, not at the end. And that point about raising it early, at trial, it was very interesting because my adversary started talking about Mr. Natter. Dr. Natter was the expert. Dr. Natter didn't have evidence to provide on this point. The person who had evidence to provide on this point was Mr. Lister, who is the trustee of the trust. We, at the time this motion was made, in our papers, and again today, I'll tell you, there was nowhere where Mr. Lister was asked about a death certificate. This issue was a contrivance well later on. He wasn't asked about it. It didn't come up. But importantly, the Mylander heirs actually did raise it because we don't think it's an issue anyhow, but we actually provided all of the proceedings in Austria. And in Austria, in the proceedings that you referred to, that you were asking about, Judge Montour, there is actually a note that there is no death certificate, right? That didn't dissuade anybody in Austria. But nonetheless, in 2021, first of all, we produced it in discovery. I realize that's not in evidence here, but what is in evidence is that in 2021, in the Mylander heirs motion for summary judgment, we actually included that. So it was right there, and that it certainly could have been raised by if the Rieger heirs thought this was something that could have been raised, they could have raised it then. Now, I want to also talk about this idea about waiver because you did ask about it. What's a little troubling is that in the reply brief, the Rieger heirs cite a First Department case and say there's a concurrence that says it could be raised at any time. It's the Pacific Northwest case. And I'm sorry, I came up during the blizzard, and as you can see, I'm working. I don't have the full set, but I might ask my colleague. It's on page 7 of their brief. It's not a concurrence, it's a dissent. And the first department said, the dissent is wrong. Every court, from the Court of Appeals to the various appellate courts to the trial courts, says you have to raise this at the first opportunity or it's waived, right? So they didn't waive it, they didn't raise it when they were supposed to, even if they could claim they didn't know when they were raising their cross claim, they certainly knew as of 2021, and this could have been developed at that time. Interestingly, and again, you'd have to look at the docket, but we were thinking about it last night. If you were to look, right before, 2 weeks before trial, the Rieger heirs filed amended answers, amended complaints. Right now, the court rejected them, but you could read those. They're certainly part of the docket. They didn't raise it there either. This was raised because they were losing the case, because they saw it was happening at trial. So it wasn't a rebuttal, and if my adversary is going to come up for a rebuttal, I challenge her to tell you where Mr. Listener said it.
We don't allow rebuttal.
Oh, okay, sorry. And then the last part is the merits, which we got to, and which is there were different organs of the Austrian government identified Eva Zirkel as an heir. And that includes, and once the Ministry of Culture did it, and you'll see it, we cite it in our brief, but you'll see it in the record, the legal advisor to the state of Austria confirmed it. He said, yes, that's right. The Albertina, as my colleague noted, which is the National Museum, recognized her as the heir. The National Museum did. So all the organs of the government, as well as not all the organs, the various organs of the government, as well as the legal advisor to the state of Austria. We think that ends this discussion. And then if it didn't, whereas what the defendants provided, it's interesting to listen to my adversary. She talks about a Dr. Hoff. That's not who they produced. They produced a genealogist, right? And the genealogist, he's not a lawyer. He wasn't qualified as such, and says, here's an expert opinion from another case having nothing to do with where nobody had a right of cross-examination. We don't know what it is, where it says there's a requirement. That's not knowledge. And what's really fascinating is we quote it's in a footnote in our papers. But if you look, Judge Doyle said, are you proposing to bring an expert on rebuttal? And Mr. Dowd said, Miss Jaffe's partner said, well, he's a fact witness. He's also an expert, but he's a fact witness, right? If he's a fact witness, what's he going to provide? And what's very interesting is that Mr. Gruber himself says, well, starting in 2006, he knew Eva Zirkel was the heir, and he was trying to get employed by her to get this death certificate. Right. So in any event, the judge was right. At the very least, there's a dispute, but Professor Groff is a professor in this area of law at the University of Salzburg. He was an advisor to the government on these types of issues. And he says, of course, she's the heir, just like everyone had said. And again, looking at it, so on the merits as well, they should lose. I want to now turn, unless you had other questions about.
I just had, and this, maybe you were going to get to this.
Yeah.
Your opponent waived an article
Yeah.
in front of us. Could you talk about that a little bit?
Sure. The article itself is from a U.S. magazine called Parnassus. Parnassus published in 1930, 2 years later, and Parnassus talked about the exhibits in Austria at the time. And not just this one, it was talking about several of them, right? And it talked about the Neue Gallery, and it did talk about the retrospective at a certain point in the article. But the Neue Gallery, as was discussed at trial by Professor Natter and the other experts, was an ongoing gallery. It continually had exhibits. All the article said was recently displayed at the Neue. Also, the Riegers take the position that everything must have come from the Rieger collection. We took the Rieger expert. Dr. Petropoulos made the same comment. When we asked him what he looked at, he didn't go beyond whatever the Riegers gave him. They didn't even give him the whole file. I took the Rieger evidence from them, showing where Tracy, and he said he'd never seen it before. We then went through the catalog raisonning, and there were dozens of other paintings that were listed as having been displayed at the Neue Gallery at that very exhibition that didn't come from Dr. Rieger. So we have, number one, the fact that the article said recently. Number two, the fact that there were more than one show. Number three, the fact that even at that 1928 retrospective, there were a number of other contributors.
And all of this was before the court that made this decision?
Yes, it was all before the court, and it came in, their expert had to begrudgingly admit it. Professor Natter showed it, and even Jane Collier and the Leman experts took issue with it, right? They didn't agree with that characterization.
So if the Rieger's claim is correct, the entire article is wrong.
If the Rieger's,
Has to, one or the other.
no,
Rieger's claim that only their works were shown at that gallery in 1928, then the article's incorrect, because the article doesn't mention this piece, it mentions lots of other pieces that weren't part of the Rieger collection.
correct. And that's also in the catalog raisonning, I think, is a better place for it. And I also want to point to one thing that my colleague made. She quoted a different article. And what it said was that Rieger gave his entire collection. It didn't say to the display. It didn't say the display is comprised only of Rieger, of works from Rieger. So it is quite possible Rieger gave his entire collection, but there were other contributors. I'd also like to talk about the other evidence, just if I could go for 2 minutes on it, which is, and first is laches. You know, we were here, and Judge Montour, I think you were sitting here during that argument, I guess 3 years ago. And let me say that my argument at that time, both below and here, was I don't think laches is consistent with the HERE Act. We lost. Right, we still our client wasn't, but what's very clear, the root of that argument.
You're arguing now that laches applies?
Certainly to them. But the ruling said, you know, laches isn't defined under federal law there. It's a state law defense. What this court ruled, and it relied on I think a Second Circuit decision saying the same thing, that the common law of the state is what applies. And to the extent that the HERE Act recognizes the common law and recognizes state law defenses, you would look at the standard based on the state law, not on the HERE Act, which doesn't specifically provide for a laches defense. Also to the laches defense, the Rieger heirs put on that case. The witnesses on laches, other than Mr. Leman, were a witness the Rieger heirs brought in from Israel and another witness they brought in from Germany. It was absolutely tried. It was certainly not advisory.
But counsel, is it my understanding that despite the fact you think laches could be applied against your opponent, that's not really where you're at. You're at that you proved it on the merits,
sure,
regardless of the procedural issues of laches.
That's right, we did, and I think that's what became unequivocal, is that if you're to read that 1960 contract, what Professor Natter did was he said, look, I'm going to look at this 1960 contract, what matches up? And he went through the entire known Sheila catalog. And he said he found 7 works that were possible matches and ruled out each one other than D 1908. So to the extent the words of the contract are correct, this was the only word. Each other expert, when asked on cross-examination, if the contract is accurate, do you have another work that fits? The answer was no. What everybody had to say instead was that the contract was wrong. That was the only way, was to argue that the contract somehow was incorrect in 2 regards. 1, the date, and 2, the description of the subject, right? The date being 1917, the description of the subject is sitting. Professor Natter explained, he was the first witness to be heard on this issue, explained that Rudolf Leopold, the author of that contract, was fastidious with dating. That's all he cared. He created his own catalog raisonne, criticizing the prior ones, because he said you have to know what order it comes in. I don't know that he's right about that, but he took it, regardless of the subject matter, he put it in chronological order. Every other expert said yes, indeed he was obsessed with the dates of works. Everyone said that about Rudolf Leopold. Number 2.
Didn't Elizabeth say that he made a mistake?
She did. Elizabeth Leopold did say that, but Elizabeth Leopold was not a party to the contract. She wasn't there at the time. What she really said was she doesn't remember owning that artwork. right? She said she believes it's a different artwork, right?
2225.
2225, exactly. At the time of her deposition, Mrs. Leopold was 97 years old. She got her birthday wrong. She couldn't remember any of the works in the contract. When I showed her that she actually saw this at a gallery, she said, "What do you want me to remember?" And she's right. She's right. That, what do I want? She's 60 years, it was at least 60 years earlier. That said, the only thing she could competently testify to is that she doesn't remember her husband owning. She wasn't a party to the contract. She wasn't there. This contract was altered. I mean, it's tiny alterations 19 times, right? Not one, and other things were fixed. This one wasn't. And again, she couldn't remember the clips. She couldn't remember the other Sheilas that were in there. So again, for her to be right, to be 2225, it would also mean Rudolph Leopold made another mistake, or not mistake, but a description which isn't warranted, which is sitting. Right. And the whole point, the professor, and again, uncontradicted by the other experts, that sitting has a meaning. The reason you want an expert here is to explain what does this mean to people in art. And 2225 shows just a bust. Right. She could be standing, she could be anything. If that were to be described by someone as sitting, any bust, any other painting could look like it was sitting. She was sitting.
Why don't you begin to wrap up, sir?
Okay. There was a full and fair litigation here. It lasted for a long time. At each step of the litigation, as you'll see in the record, every time something came out, the Riegers would throw out another defense and saying, this is why they win, this is why they win. What they never address, and what you don't hear them really address, what wasn't addressed today, is that we took their expert through Mr. Rieger's, Dr. Rieger, sorry, ownership, and we showed exactly what number, what the painting was, and he couldn't contradict it. He didn't have a response to it. We said it is clear that painting went on to France. We know exactly. We have a picture of it. That, Your Honor, when you say, well, Parnassus is a picture, we actually have, and it's in the record, the pictures of what traveled and what portrait it was, and it wasn't D1908. I'm sorry, was it D1937? What is it? D1709 was what that picture was. They never owned it. It was owned by Carl Meilander. Carl Meilander, Ava Zirkel was brought to the court. Ava Zirkel was in the one piece where I agree with my adversary. Ava Zirkel was identified after painstaking, and it wasn't by the IKG. It wasn't the IKG who said, let's restitute. It wasn't the IKG. It was the government of Austria who said, we need to find, and did they rely on the IKG? They did, but they said, we need to find the heir of Carl Meilander. And they did, and they found Ava Zirkel. He was the right plaintiff.
Thank you.
Thank you.
No. Okay, our last case for argument today, case number 170, Morgan versus the Village of Mohawk. Both by video. Okay, I see Mr. Morgan.
Good morning, Your Honors. I seem to be having some technical difficulties here. I'm trying to figure this out.
Okay, well, take your time.
There we go.
All right, very good. Okay, can everybody hear us?
Yes. Yes, Your Honor.
Okay, then I guess, Mr. Morgan, the floor is yours.
Yeah, I'm not an attorney, but I am a whistleblower, and I need to get everything on paper so the public, when I go public with my cases. So first,
Just so you know, I'll just start this out by saying, we read everything. Okay, we were given a record and your briefs. And so you could start by knowing that we understand the underlying facts. We're more, I guess, interested in this point in time is the legal argument with regard to the effect of your pleading or being found guilty and not appealing. You could talk about that. I think that's kind of the whole ball of wax there, sir.
I got points, but I signed an agreement. I can talk about certain things, but on a parallel case, so I got to be careful what I say. On my point one, I'll talk about both. Dismiss the false arrest. No crime was committed. If you watch the videos, I wasn't doing anything wrong. Point two, the judge forced me to do the trial by myself. Obviously, I'm not a good attorney. He didn't appoint me a new public defender. Therefore, I didn't have a full and fair opportunity to litigate at trial. Point three.
Okay, and if that was, let me just, we'll be a little interactive here. If that was so, okay, and you felt that that was a mistake that the lower court made, at some point you could have, up to a certain point, appealed that decision, okay, and said the court made a mistake by not giving me a lawyer and presented your proof on that. But this record does not include any indication that you did so.
Oh,
is that right?
The appeal? Okay. Points.
So no, I'm asking, I guess I should have asked it as a question. Is there something that we're missing? Was there an appeal? And was that appeal based on the fact that the court made an error in not giving you a lawyer?
I filed the notice before my trial. So I had a 58 hearing with John Bailey. I didn't deal with Ryan. I don't understand the question. Yeah, this is an appeal to the Supreme Court judge. I brought that up. Is that what you mean?
Well, why don't I allow you to give us your argument?
He also, I can't keep buying these transcripts of what I said to judges, but I did. And I don't know if I had it at the time. He said I said the Supreme Court Judge Mark Rose erred on that I only offer hearsay statement that a criminal court judge would not conduct a trial unless plaintiff had counsel. He promised me. Both of these judges were my friends. Anyway, he went back on his promise. It wasn't my fault that they waited almost a year. Well, it took a while to get me a public defender from 3 counties away. I did hear some letters from Judge Engert, the lowest court, where they actually swore in the letters saying, don't ask me to represent him again. And anyway, so I knew I wasn't going to get a competent or one that didn't have a conflict. But anyway, point one for his existence of probable cause for an arrest is a complete defense to allegations of false and retaliatory arrest. He like during the trial, Joan Minor admitted under oath that she was the anonymous tip to the officer. She's also the complainant. And because of that, there was no probable cause, and there's no video proof of the officer being near West Main Street that day to witness anything in her presence until she pulled up in front of my truck. So there's
now we're discussing the facts underlying your conviction. Okay.
Yes, because he said a collateral stop. I can't
collateral estoppel is indeed
relitigate the same issues, which is fine. But the officer obviously lied, because if you watch the video when I'm out in front of the house, it doesn't matter. Anyway, on on his point 2 about the fair, he said I had a fair and full and fair opportunity. And like I said, it wasn't my fault that he couldn't find me another attorney before the 1 year expired. And then on point 3, he said the record is on appeal is so deficient. I don't know what he means by that. It's complete. I think I gave you everything that was certified by the clerk and by a court order by you guys to give it to me. So I don't know, understand that one at all. So anyway,
We have your papers. Do you rest on your papers, sir?
no, I just want it for the record. I had nothing to do with Dave and Joan's deaths next door. And I also want to say to keep in mind that the miners did not own the house on West Main Street. They chose to pay rent to stay in a house next to a house that I owned and resided at. I just want that to be out there. And from the beginning, the justice system failed me. I requested a restraining order on the minor, and instead Judge Garamone granted an order against me for them, and it stayed on for 7 or 8 years. So there's more to this. I have 2 more cases that in 4 days you guys got to decide on motion to vacate the Faxon St. Luke's Healthcare and the city of Utica. I hope you
Okay.
make.
There'll probably be some of us, but not all of us. Probably be a different panel by then.
Correct.
Thank
Yep.
you. Thank you, Mr. Morgan.
Yep. Thank you, guys.
Okay. Oh, not a problem. Okay, counsel, would you like to respond?
Good morning, Your Honor. May it please the court. My name is Ryan Bailey. I'm here on behalf of the village. I'm going to be very, very brief.
We have read your papers and your briefs.
Yes, Your Honor. The only thing that I would request is that if the court does see an issue with collateral estoppel, I would just respectfully request that the court consider the interaction between the plaintiff and Officer Jones in the context of a domestic dispute. I know that courts recognize that domestic disputes, they create a heightened sense of concern for victim safety and the challenges that law enforcement have to face. Under these particular circumstances, Mr. Morgan's documented history with the minors, including the family court matters, and Officer Jones' knowledge of that information, as well as the observations that she made there, create sufficient basis to establish probable cause for harassment. And that is the only thing that I want to say, Your Honor.
Okay, thank you very much. Thank you both.
Thank you, Your Honor.
Good day.